Brazel, case number 2025 DM 58. The petitioner appears in the office of her attorney, Richard Thompson. The respondent appears in the office of his attorney, Matthew Olson. This matter comes before the court at this time for hearing on at least one motion and perhaps two. Counsel, there appears to be two motions that have been recently filed by Mr. Olson on behalf of his client. Are either one of those resolved, Mr. Olson?
I believe the motion for access to the workshop, Mr. Thompson had a couple of changes to some verbiage within the order. And please correct me if I'm wrong, Rick. We made those changes. I've attached the proposed revised order as our Exhibit H. So as far as the terms, I believe we have it resolved. The only outstanding issue that we've spent a lot of time going back and forth on is trying to schedule a date and time for this to happen. There's been disagreements on either being in the middle of the week, which is very difficult for my client because he's working or has to leave work, and then he has difficulty finding people to help him. And then there's been some scheduling conflicts. The parties utilized the petitioner's father the last time, so this would be the second time that we're trying to get this property exchange resolved. But then there was some scheduling conflicts with him. So I've got a couple of weekends proposed. The other issue, Your Honor, was a weekend or two that was proposed by Mr. Thompson. My client had the minor child. He's not taking the minor child out there for the property exchange. He doesn't want to take the minor child with him and wants to do it on a weekend where he doesn't have parenting time. So I think we need to get a firm date that works for everyone. And that would be the only outstanding issue with respect to that motion.
Mr. Thompson, do you disagree with anything that Mr. Olson just related to the court?
Your Honor, the order, no, I do not. The order does have my proposed changes. The problem had been a date. There's supposed to be a third-party monitor, and it's not been Southern Brazil's issue. It's been trying to get the third-party monitor lined up when Mr. Brazel wants to do it. That's been the issue, Your Honor. And we proposed a number of dates. Mr. Brazel didn't want to do it. He proposed a couple, I think one of which was Valentine's Day, and the third-party monitor couldn't do that. So we've been trying to work through that, Your Honor.
Can't we just schedule this on a weekend sometime?
That was our suggestion, Your Honor. It's just a function of getting a third-party monitor. And then Mr. Olson had suggested using the sheriff's office, but we haven't received any word from Mr. Brazel's side of the case about that. Yeah, weekends, I think, is what should happen.
All right. Mr. Olson, would that be a problem just to schedule that for a Saturday here?
No problem at all, Your Honor. Again, my client's got limited time on the weekends with the son, so he would just ask it and not be a time that he has parenting time the weekend. I know he's available the 21st of February or March 7th, or two dates upcoming that work for him. But yeah, absolutely, a weekend would be preferable, Your Honor.
I would also think as soon as possible would be preferable.
Yes, Your Honor.
All right.
Yeah,
so why not February 21st?
It's the third-party monitor, Your Honor. We don't.
Well, find a different third-party monitor then. If that's holding things up, I think you just need to find a different third-party monitor.
Yeah, we agree completely, Your Honor. Yeah.
Can that be accomplished here this week, Mr. Olson?
Absolutely, Your Honor.
All right. What time would we be starting this? I think you would ask for a 6-hour period.
Yes, Your Honor. 8, 9 a.m., whatever works.
Want to do 9 a.m.? No, we have no 9 a.m. We're fine, Your Honor.
Okay. 9 a.m. February 21 would be the time that the exchange would begin and entry onto the property for purposes of taking these items in accord with whatever agreement's been reached. And hopefully you can agree on this third-party monitor over the course of the next couple of days so that this can take place without a problem.
Yes,
I also wanted to wish the parties happy anniversary. Your divorce case is 1 year old as of today, which is disturbing to the court. We do not appear to be close to a final resolution, and that is troubling, quite frankly, and the court wants to see it change. We'll get into the other motion that may be before the court this morning, but Counsel, the next thing we're going to do is that we're going to schedule a trial date before we go any further with this case. We are going to reach a final resolution at some point. What still needs to be done as far as preparation, Mr. Thompson, before you're ready to try whatever issues remain?
Your Honor, we, Mr. Olson and I discussed this. We had a meeting last month. We discussed this briefly. There will need to be some appraisals that need to be done. There are a number of LLCs that have some real estate involved. That's been part of the issue. We need to get a joint a business valuation. And I think we talked about Jeffrey Quirin. I know the court has experience with Dr. Quirin. At least in cases I've had. And I think Matt and Mr. Olson and I believe, discussed that briefly last month in a meeting that we had.
All right, Mr. Olson.
I'm sorry, and Mr. Sanmaniego has domestic conciliation, Your Honor. It's my understanding, he had the final interviews with the parties Friday. And so hopefully we'll get a recommendation in the short term, Your Honor. That will go a long way toward getting some of these other issues resolved.
All right, Mr. Olson, what would you add to that?
There's some discovery. I'm going to send a follow-up letter to Mr. Thompson. We've issued discovery. We've got responses back. There's some other things that still need to be provided. So I'm going to get a letter over, if not today, Your Honor, hopefully tomorrow, to Mr. Thompson of remaining discovery. But everything else that Mr. Thompson's relayed to the court is what we've discussed. And I would say, Your Honor, Mr. Thompson and I have probably met or discussed, probably not, if not weekly, bi-weekly, with respect to this case. So I would, not that makes much difference, Your Honor, but I would say that he and I are very much cognizant of the time lapse on the case and trying to get it moving forward. I would say more than anything, the biggest holdup is the DC recommendation. And I know Mr. Sanmaniego is aware of the parties want to get this thing moving. And I know he's going to, at least from my understanding, he's going to try to expedite getting a recommendation put forth because that would be the only other tie-up issue beyond some appraisals and the discovery and any involvement Jeff Quirin has.
And Your Honor, one last thing, and I just slightly, Mr. Olson and I's defense, we are second counsel each in the case. So we have not been engaged for the whole year. We have done, I know, Your Honor, that doesn't help the scheduling, but
we're the ones that are going to be held accountable now.
I know, Your Honor. I know, Your Honor. We're all grinning about it, but I thought, shoot, I got to bring that up at least.
All right. Hearing that there's going to be need for appraisals, perhaps some additional discovery, I think we're looking at least 2 months out. I can offer a mid-April trial date. Is that being overly optimistic, Mr. Olson?
I believe so, Your Honor. And if anything, is particularly with Jeff Quirin, I know he's, and I'm sure Rick's probably using him too or involved with him. I think I've got Jeff on at least 2 other cases right now, and I know he's been busy. And I just think with getting everything put together that we need and then having that prepared or ready to go for purposes of a trial date, 2 months would be hard. I think the court may want to hit me after this. I think maybe in June-ish would be probably the most feasible time now. The other thing I'll throw out there, Your Honor, and I understand the court's position on this, and Rick and I can follow up and do it. This case, honestly, once we get the domestic conciliation recommendation back and everybody's got their due diligence complete, we have a full picture where we're at. I mean, like, this case would still be right for mediation. But I think June would probably be the best date where we sit here in the middle of February.
I can offer Tuesday, June 9. Obviously, an in-person proceeding in El Dorado. June 9, starting at 9.
I'm available, Your Honor.
Mr. Thompson?
Yes, Your Honor. Bear with me, please. As the court recalls, whenever I schedule my own, I usually get in trouble. But my June 9th, I just have an outside meeting, which I can postpone or otherwise not attend, Your Honor. So June 9th, I look good.
All right.
And if I'm not, Aaron will notify you immediately if I messed up. So,
all right. Tuesday, June 9, 9 o'clock a.m. start, courtroom B, Butler County Judicial Center is established as the trial date and time in this case. We need to schedule quickly regarding anything that still needs to be done to work toward that date. That seems a long way off, but it'll be here before we know it. So the sooner that the appraisals get scheduled and organized, I'd also encourage a mediation in this case. The Wichita metro area is blessed with several qualified mediators, even in domestic cases. So I highly encourage that if council believes that that would be fruitful. But I do want to work toward a final resolution of the case, and Tuesday, June 9 is established as a trial date. Now that it appears that the motion for access to the workshop has been resolved by agreements of the parties, do we still have issues regarding the motion for reimbursement from real property sale proceeds?
Unfortunately, we do, Your Honor.
Is any part of that resolved, Mr. Olson?
I do not believe so. I would say Mr. Thompson has, well, I'll let Rick, I don't speak on his behalf. So the point is, Your Honor, there's a credit card that needs paid off. It's about $26,000, and I'll get into it in more detail. There's been a discussion on paying some of that off. So I guess, Rick, not to throw this on you, if that's the starting point of what you've proposed to do, at least to pay off that balance, then that would be the only thing that we've worked through. Otherwise, Your Honor, we would like the court to intervene and make a decision on it.
All right. The credit card debt appears to be almost $27,000. And how much do you actually have in funds in your account, Mr. Thompson?
Approximately $60,000, Your Honor. It's a little bit more than that, but approximately $60,000.
Here's the core fight. Is this credit card marital debt or strictly LLC business expense? One side says most charges relate to renovations. The other warns about personal spending hidden inside. The legal distinction matters. LLC funds cannot casually cover personal obligations without consequences for liability protections.
All right. It appears that obviously the credit card bill could be paid off in full with the proceeds.
I don't want to get into my argument, Your Honor, but there is an issue with that. The parties, these funds do not belong to the parties. This is a limited liability company, Your Honor. So the way the motion reads, it reads as if these are dollars from the proceeds of a sale of a home owned by Mr. and Mrs. Brazel. It is not the case. Exhibit B that Mr. Olson provided is the closing statement, and the seller is 423 Investments LLC, obviously a different legal entity than the parties. The parties are members of that LLC, Your Honor. The problem that we have in paying this credit card statement is that there are bills, there are charges associated with that statement that do not involve this LLC. There are personal charges that Mr. Brazel made. I pointed out some of them to Mr. Olson. Mr. Brazel pointed out some personal charges that Ms. Brazel has made. We also believe that there are charges on this card that do not relate to this limited liability company or this flip house. I put in correspondence. Matt and I met, Mr. Olson and I met about a month ago to go over some of these items. We had a good meeting, a couple hours, and I was able to account for about $10,000 from the credit card statement that related to this flip house, provided Mr. Brazel provided a statement that these charges to Menards and Lowe's related to the flip house. Mr. Brazel has an outside construction drywall company, Your Honor. And so there's a concern that he was using this credit card for his other jobs and for other projects that do not involve this limited liability company. And if we go down the road of we're using the money that this limited liability company owns to pay personal and other expenses not related to the limited liability company, then you lose the protection of that limited liability company. So the bottom line is the parties do not own these dollars. The limited liability company does. The parties are members of that limited liability company. And one suggestion was if there are bills that Mr. Brazel wants paid, there are bills that Ms. Sudduth wants paid, the limited liability company, based on what the two members want to do, can distribute those dollars evenly. And then the parties pay those bills, which they believe appropriate to be paid, and then we sort it out at trial, Your Honor. Because there are a number, and I don't want to go before Mr. Olson's argument. There are a number of other issues we have with some of the expenses incurred, but the threshold issue is these are limited liability company dollars, Your Honor, not the party's individual dollars. So while I think paying off marital debt is great, technically, according to limited liability company, we shouldn't be using that limited liability company money to pay off their personal debt at this point, unless it's distributed. I mean,
All right. Mr. Thompson, have you provided a list to Mr. Olson as to what is undisputed to be limited liability company charges?
I provided we receive an affidavit from Mr. Brazil that these charges to the Menards and the Lowe's were directed toward the 423 Investment LLC project. Yes, Your Honor, I did, and they're in my exhibits, Your Honor. I sent Mr. Olson some letters.
Is that correct, Mr. Olson?
It is, Your Honor, and my client's got no problem signing an affidavit with respect to that. I would add, and I'm sorry not to circumvent when the court's going, this card that we're dealing with here was opened in May of 2022. These parties were married in April of 2021. So the card's entire existence was only during the marriage. I would tell the court, and that's why I provided all this statements under Exhibit C for the card in its entire existence is, I would tell you, 80 to 90% of the charges on this card have been for renovation projects, not only with this flip house, but other properties that the parties have owned. You can look, there's all kinds of transactions to Floor and Decor, Lowe's, Menards. I would tell the court that there are some food transactions that were done by my client. I've talked to him. He'd be willing to sign an affidavit, even swearing to that those food transactions would have been for him taking out some of the guys that are working for him during the day if they went to get lunch or buying lunch or whatever. So all of the expenses, but for, I want to say 4 transactions from my client, and the card statements are very helpful, Your Honor, because it shows whose card is doing what. So there's charges for respondent and then charges that the petitioner used the card for as well. But all of the existence of a balance on this card has been for renovation projects or this flip house as well. And the other thing I point out with that is the petitioners used the card for expenses for the flip houses. There's some food transactions and things like that as well from prior, where the balance would have been paid off before or prior to the balance we're dealing with now. But there were 4 transactions. I think the trash bill for the lake house was paid, and I think it was about $38 for all 4 of those. Those would be the only 4 that would not be quote unquote for renovation projects or this flip house. So not to oversimplify this, but our position is it's the card in and of itself is either marital debt or a debt that's been created through the 423 Investments LLC. It should get paid off. Now, I don't think it's that complicated. The parties can either decide to pay off the balance as an expense for the business, because I think the existing balance that we're dealing with now, I would say almost all of it, but for those 4 transactions, was with respect to business expenses for 423 investments. So the business should be able to pay this off. If there was some other concerns or complexity with it, then the parties can take or there can be a distribution made to pay it off. So, I mean, the money's sit in an account, understanding that there's an LLC. I would still say it's not that complicated. It's a marital debt. My client continues to have to pay interest on it. He's paid $3,200 to date because he's been making the minimum payments since July of 2025. And so the interest, we continue to pay interest on it. And the card balance just needs to be paid off because it's going to benefit both of the parties. So anyway, I know that's more than the court wanted to hear with respect to its question, but we have no problem signing an affidavit. I know one of the concerns Mr. Thompson has noted is that, well, there's a expense to Menards. Did your client take that use that and then use that the expense for another project or item on some other project he was doing outside of this business, or did he take it back and get a refund? And we would be willing to sign any affidavit that Mr. Thompson felt comfortable with But our position is, but for those 4 transactions for the lake house, which is still for the benefit of both the parties for purposes of this case, all of the expenses on there that are in existence that my client would have been either for this flip house, which I think are most of them, or for purposes of other rental properties. That's just why the parties used the card for the most part.
The 4 transactions are A, B, C, and D under paragraph 5 of your motion. Are those the
Yes, Your
same
Honor.
4 transactions that you're referencing?
Those are expenses that petitioner used initially. Were used for, I think was this when she was traveling to Hawaii? Those are 4 transactions that the petitioner used the card for on those respective dates that I think would not be legitimate expenses for the LLC. That's why we carved those out. There are 4 additional transactions for the monthly trash payment for the lake house in addition to those.
Okay,
And Your Honor, if I may,
go ahead.
the argument has a bit of a confusion. We're talking about marital debt. This credit card, what I'm being told, is supposed to be the limited liability company debt. Different, Your Honor. What I heard an argument is that this credit card that's supposed to be for the 423 Investments LLC had other projects on it. It may have been during the course of the marriage, but those other projects do not relate to the 423 Investments LLC. Some of them predate when this flip house was purchased for the parties to flip. That's the concern we have. The first batch of credit card receipts that I received from Mr. Olson, they had $10,605.24 that appeared to be related to this home, the 423 Investments LLC home. We can't tell because they're for Lowe's and Mr. Brazel has a drywall business. That's where the affidavit comes in. Then after our January meeting, Mr. Olson's office sent me another tranche of credit card receipts. The first batch was incomplete. They were after the home was sold, and there's approximately another $6,000 that appeared to be related to this LLC's project. Then I pointed out that there's still a discrepancy of over $10,000 between what Mr. Brazel was asking for and what the credit card receipts show. I then received a third tranche of credit card statements, and a number of these predated when this home was purchased for them to rehab and sell. That's where the concern comes in, Your Honor, where we're using this LLC's credit card for purchases that do not relate to this LLC, Your Honor. That's where a discrepancy comes in. It may be marital debt. I don't know if it was his business. I don't know if it was his business debt or not. I haven't received that information from Mr. Brazel, but it does not appear related to this LLC and the home that was part of this LLC because it predated that home purchase.
Now the timeline becomes explosive. Some credit card charges allegedly predate the flip house purchase. If true, that weakens the argument they belong to this specific LLC project. That's why documentation matters. Without clear tracing, business expenses can blur dangerously into personal financial territory.
That's one of the issues we have, Your Honor. We have absolutely no objection to the LLC money paying for the LLC expenses. None. The problem we have is when we're taking those LLC dollars and using them for non-LLC expenses. If the LLC is to distribute those dollars to the members, which are the parties, then so be it. They can spend that as they see fit, Your Honor. Whether it be reimbursing Mr. Brazel for what he claims to be his expenses, for labor, reimburse Ms. Sudduth for what she claims to be her expenses, so be it. And then we can sort out the marital portion of it at trial. But Your Honor, what our position is, you should limit, we have to limit the LLC dollars to LLC expenses until they're distributed.
And what amount is that, Mr. Thompson?
The LLC, based on my review, it is, bear with me, Your Honor. I show it is $16,597 $0.30 as the expenses that ought to be reimbursed, subject to Mr. Brazel providing this affidavit.
All right. Which Mr. Olson is committed to.
Correct, Your Honor.
If I may clarify, Your Honor, I'm sorry.
Go ahead.
The parties have 11 duplexes. This 423 Investments LLC was created by the parties when they got married. This card has been used. I mean, there are more. 423 LLC deals with the duplexes and a number of rentals and flip houses. I think the parties had 2 flip houses at one time. So it's not just exclusive to the Washington residents. So other expenses that would have been used for the duplexes, which they were doing some renovation work on, or flip houses, even in addition to the Washington flip house, are all legitimate expenses. So I just want to clarify that the flip house in question is not the only legitimate expense for purposes of this LLC. The other thing that I misspoke, and I apologize, is the lake house is part of 423 LLC. So arguably even the trash bills that have been paid for the lake house would be legitimate expenses, as that lake house is part of 423 investments. So but for the 4 transactions in paragraph 5, and maybe taking some time to go through to verify that there aren't other personal transactions that the petitioner may have used this card for, although I would say, I believe all those predate a time when the balance was paid off during the marriage. I mean, those would be the only arguably non-legitimate business expenses. I don't think the parties would have any issue. My client, again, will sign any affidavit that Mr. Thompson wants to say that the expenses that on his card expenses for this card were for purposes of 423 LLC.
And Your Honor, as to the lake house expense, that has come into question because Mr. Brazel on his domestic relations affidavit indicated he was paying that expense personally. That was just one thing that cropped up as a red flag.
Well, it would seem to make practical sense, counsel, that if it's undisputed that $16,597.30 is legitimate LLC debt, let's get that paid. Let's reduce the credit card debt to the extent we can at this juncture. And it could be that there are some legitimate disputes regarding the remainder that need to be sorted out. But the court would direct an order at this point that $16,597.30 be taken out of the funds that are being held for the LLC and applied to LLC debt. Now, I understand it, Mr. Olson, that that's going to be supported by a promptly drafted affidavit by you and signed by your client?
Yes, sure.
Okay. Well, upon receipt of that affidavit, the court would direct that Mr. Thompson make the distribution.
Your Honor, may I make one suggestion?
You may.
I have these dollars sitting in my trust account, and as the court knows, that's not drawing interest. Well, it's not drawing interest to benefit the parties. It goes to IOLTA. If we could distribute that 1/2 to each of the parties with an admonition that they not liquidate those dollars, that they keep those, at least maybe they'll be earning some interest on it. We're okay keeping it in my trust account. You know, our accounting folks always like for us to clear those things out, but it might make sense to distribute it with an admonition that, or not admonition, an order that do not spend this money except for the $16,597.30 of the court order. That
well, I would trust that would be a distribution off the top.
Correct, Your Honor.
Okay. Mr. Olson, your thoughts in that regard?
I mean, it makes sense, and I appreciate where Rick is coming from, Your Honor. I just have concerns. You know, obviously, any potential that there's going to be accusations or other problems we're going to have to deal with moving forward. I think that could make that ripe for that to happen. I don't think as long as we're paying off the $16,000 off top, that's great. If the court's inclined to put the money or remove the remaining funds from Mr. Thompson's trust account and put it into a joint account that the parties have, that neither one of them are allowed to touch, but both can monitor instead of splitting it up to either of them. I mean, I probably could be okay with that. But I think when we start splitting it, then there's 2 accounts that both of them only have access to. I think that's just going to create a potential other issue that we may have to deal with at the time of trial, and as we're trying to get this case wrapped up in the next few months. It just adds more complexity to it. So, and I understand, I don't know what interest rate. I mean, if you're going to get a 1% interest rate on a basic, savings account at a bank. I don't know how much, I don't think that's going to be that profitable. So I mean, it probably will just be easier to keep it in Mr. Thompson's trust account so we can avoid any further problems.
All right. Mr. Thompson, you've heard Mr. Olson's response.
Yes, Your Honor. I wanted to make the offer. I just didn't want, if the parties think they can make some money on this, great. I wanted to provide that opportunity for counsel and the court to make that determination. And plus, I can tell accounting that I brought it up.
Yeah. Well, there does not appear to be a clear-cut agreement in that regard. Therefore, the court will not order it.
Now we enter the labor dispute. He claims roughly $8,000 still owed at $60 an hour. She argues he already took $20,000 and inflated additional hours after divorce filing. The judge presses for clarity. Were payments draws, payroll, or compensation? Documentation will decide credibility here.
Mr. Olson, I was particularly intrigued about your client's request for reimbursement of labor costs that he's put in.
Yes, sir.
To one particular project. And apparently nothing has been dispersed from this LLC money to reimburse him.
So there's a breakdown, Your Honor, that's under Exhibit D of, it's actually would be base stamp page 132 in the notebook where it says Washington at the top. This would be an itemization in the ledger of the time that my client put in along with two others that have helped him. He is paid, those would be delineated by Russ and is that Nick? Which he's already paid Russ and Nick for their time in. So there's out of all the hours, there have been some payments made to my client. I think there's still roughly $8,000 that he would be owed for his time. I know that's been a dispute as to whether or not he should be reimbursed for that. I'm trying to look at the total cost that he'd been paid without just giving the court an estimate. I think he's been paid roughly $20,000 for the time and work that he put in, but there's still $8,000 owing. If the court is inclined, I know he would like to get paid the rest of the money that he is owed. And again, I know there's a dispute. He billed at $60 an hour. I would say my client's pretty skilled and seasoned at his work and doing drywall among other things. And I believe, Matt, please correct me if I'm wrong, during the course of the marriage, when you would do the work on the duplexes and any flip houses, that's what you paid yourself.
Yeah.
So I don't think the amount or the dollar amount per hour that he's asking for is anything different than what he would have been paid by the LLC during the course of the marriage. So that is still outstanding. That he would like to get paid for that. The one thing I would note for purposes of this, Your Honor, when this Washington property sold, and I think it's under Exhibit B, the closing statement, the petitioner did pay herself a brokerage fee. I think it was $61.50 that she got paid out of it. And the other issue that came up with respect to this, my client getting paid his time that he still is owed for this Washington property was we had a number of communications back and forth between Mr. Thompson and I. There was at one point the parties took out a $50,000 loan to do some renovation work on a number of their 11 duplexes rentals that they owned. At one point in time, specifically, I'll say, Your Honor, on April 3rd of 2025, so this would have been about 6 weeks after the case was filed, the petitioner took $10,000 out of the 423 investment account and paid that into her Caitlin Suddeth Realty bank account. We've provided that information in exhibits. We got F. And Mr. Thompson sent me some correspondence trying to track. I mean, trying to track that she had paid 423 Investments was owed money, or Caitlin Suddeth Realty was owed money, like $10,000 at one point in time, and that the money was paid, or 423 Investments paid in February of 2025, and then Caitlin Suddeth Realty reimbursed 423 investments or whatnot. I don't necessarily have that straight, and I thought it was pretty confusing. But the reality of it is, Your Honor, the $10,000 on April 3rd of 2025 has never been paid back to 423 Investments. So for purposes of this particular issue, my client would like to have an additional $8,000 out of the proceeds sitting in Mr. Thompson's trust account. That would be a legitimate expense for the business because that's time that's still owing to him. Obviously, that's disputed, but we've never gotten to the bottom of why he's not been able to get that paid. But for the petitioner removing that $10,000 from the business investment account in April, my client would have been able to get paid the money he's owed.
All right, Mr. Thompson, why wouldn't this be a legitimate expense of the LLC at this point?
There's twofold, Your Honor. One is we do not believe that the hours that he claims not to be paid, he actually worked or he wasn't paid. He did receive $20,000. He took $20,000 out for his labor costs. The additional labor cost is something that Ms. Sudith, as an equal member in the LLC, did not approve of. It wasn't run by her. It is over and above the expectation of what it would have cost to have this house ready, Your Honor. Plus, when we look at Mr. Brazel's past tax returns, other evidences of income, he is not getting $60 an hour on his projects. We believe he is inflating his wage after the divorce was filed in order to maximize his recovery from the LLC proceeds, to which he's a 50% member, Your Honor. So we have several different levels of objection to this, Your Honor. He gave a handwritten spreadsheet. We don't even believe that he was at the home for the hours that he provided on his handwritten spreadsheet, Your Honor. We also believe the $20,000 was it for his labor expense. Then he came up with another $8,000, Your Honor. $20,000 might be high, but Ms. Sudith was going to acquiesce to that as the cost of doing business. But when she was hit with an additional $8,000, that was too much based upon what was put into this home. And we do not believe Mr. Brazel actually did that, Your Honor. We think he just hand wrote a bunch of these things down and said, I'm going to get paid from this. But the dollars were in our trust account and he could not, as Mr. Olson said, grab those out and take them, Your Honor.
This is where tension peaks. Allegations of inflated billing, handwritten spreadsheets, and post-divorce bitterness surface openly. The court wisely refuses to rush judgment. Without verified third-party payments and clearer breakdowns, no immediate reimbursement. In business disputes, paper trails beat emotions every single time.
Reply argument, Mr. Olson?
I mean, the $60 an hour was paid out with the total, at least the $20,000 that were paid to him. Again, this is something that he did the work. And actually, I would tell the court on this Washington property, once the divorce was filed, I don't think petitioner really had much to do with the flip house anymore. My client was the one responsible for getting the work completed on it and getting the house ready to be sold, which the parties made a profit on. So he took exclusive control over that. Again, it was no issue during the time of the marriage that he got paid this amount per hour. Again, he's very skilled at what he does, and he has other work that people hire him to do. So, unfortunately, as you know, the court's aware, the bitterness that comes up in a domestic case, unfortunately, raffles its way into all aspects of it. Things that were perfectly fine and normal when two people were married are all of a sudden an issue after the fact. I mean, again, especially in light of the fact that the petitioner took $10,000 out of the account that's never been accounted for. I think my client should be entitled to at least the $8,000 of labor that he has put into it. This would be the only thing that I believe.
Yeah, but Mr. Olson, let me stop you there. Didn't he already bill the LLC and get paid for $20,000? Wouldn't there have been at least a reasonable expectation that when he was billing for his labor, he was doing it all at once?
Would you clarify that for me?
Yeah. So, in my business, I pay the guys on Friday. Eventually, I had to pull draws out. So the other two transactions were not just one; it was twice. That totaled to 22. I was giving myself a draw to get my business account money to pay the guys and have a little bit of payment myself. So I was paid up till, and then at the end I had to finish the flip house And then that was one final bill was the 8,000 at the very end.
That would be why.
Yeah.
And I trust that the breakdown of the labor he paid to third parties has been provided to Mr. Thompson? That was part of the 20?
Your Honor, the breakdown of the third parties, I do not recall seeing that. I'll ask Mr. Olson. I received the spreadsheet,
It's
a handwritten
transfer
spreadsheet.
checks at my bank, so we can provide it.
We can, I don't know if we provided that to you, Rick. I will absolutely get them. They were bank transfers through checks. So if not, I will track that down. But again, he paid us.
Sign an affidavit too.
He'll sign an affidavit with that respect to, Your Honor. He paid out his employees. So
What
All
I
right, Mr.
recall,
Olson, obviously that's a difference that makes a difference to the court.
certainly.
If the 20,000 was for the payment of labor to third parties, that certainly would have an impact on what the value of his personal time is worth and whether it's been adequately compensated for or not. So I don't think the court's in a position to make a ruling today, but I'm not ruling against your request, Mr. Olson, but I don't think that there's been enough information exchanged to clarify that point. So
And
the
Your Honor,
court
what
at
I
this
will
point will
report-
reserve that issue.
I'm sorry, what I'll report is I did receive a handwritten spreadsheet, and the third party's hours do not equal $20,000, but I just have a handwritten note, Your Honor, for lack of better term.
It's fine. There's
We can give a more thorough itemization of it, Your Honor.
Also direct. All right, Mr. Olson, as far as issues today, what else do we have to deal with?
I think that's,
And-
I don't believe there's anything else, Your Honor.
What about the global settlement offer that was referred to in your motion? Will there be one from either side to the other?
I think we've got to get in a position where Mr. Thompson and I have done our due diligence so we can sit down with our clients and tell them what's what. I think that's probably what the holdup is. And the other thing is too, obviously, you know, with when you've got a kiddo involved, that's the driving force. The parents need to know what that's going to be with respect to the domestic conciliation recommendation. I know I'm not to disclose anything confidential, and I'm sure Mr. Thompson's had the same conversation with his client, but I told my client particularly this court's thoughts in the local courtroom of Butler County with respect to recommendations and whatnot. So those would have to be done first before we would be in a position to do that. Again, Your Honor, hope springs eternal, as the expression goes. This is not a long-term marriage. So, I think the case would hopefully be in a position or ripe for either a settlement or mediation. But we've got to get those other financial things with valuations and stuff done first.
I think that's a fair explanation, Mr. Olson. All right, if that resolves the issues at this point, Mr. Olson, I'm going to task you with drafting a journal entry documenting the court's rulings made here today, including the trial date that the court has established in the case.
Yes, sir.
Mr. Thompson, anything further we need to address today?
No, Your Honor, thank you.
Very well. And if there's nothing further at this time, this matter will currently be in recess, and this meeting.
The hearing ends, but resolution remains distant. Partial credit card payment ordered, labor reimbursement reserved, and trial set for June 9th. Mediation is encouraged, but pressure is building fast. Like, comment, and subscribe for more shocking courtroom stories and powerful legal breakdowns you won't want to miss.